Welcome all of you, welcome back. In this video, we will discuss about the approach to law optional, and specifically we will discuss about paper 2. In the first video, we discussed about paper 1, constitutional and administrative law, and in this video we will discuss with you about paper 2. In paper 2, in section 1, we have law of crimes, which is mainly concerned with IPC, and along with this we have law of torts as well, and then we have mercantile law, and along with mercantile law we have the contemporary legal development, CLD. So in this lecture we will discuss about how to approach in this paper 2, because I presume that you have gone through this entire syllabus already, that's why you are appearing for this mains test series. Okay, so in this approach to law optional paper 2, I will discuss with you how to prepare for law of crimes, law of torts, law of contract and other mercantile related subjects like Sales of Goods Act, Partnership Act, and then the contemporary legal developments. If you go by the contents of the CLD, you will be in a shock. It includes public interest litigation, it includes IPR, cyber law, information technology law, competition law, ADR, environmental law, right to information, and trial by media. It includes number of subjects. So generally the biggest mistake which the aspirants make is they start reading entire subject in CLD. Please mind it, it is contemporary legal developments in those specific subjects. It is not about the complete subject. It is not about the complete subject. It is only about the latest developments. Like for example, government has gone through the recent amendments in competition law. So what are those amendments? Whether those amendments were really necessary, or whether what is the importance of those amendments? What should happen after those amendments? Or are they sufficient to meet the lacunas? What should be the answer? Like similarly, government is in discussion with respect to the regulation of the social media, the guidelines. In the past as well, government has issued sometimes the guidelines regarding the regulation of media. So we have to just focus upon those things, the latest advancements which are happening in CLD. Why I am telling you about CLD first? I have seen that many of the aspirants, they worry in CLD. And they start reading cyber law, complete IT law, complete IPR, complete competition law, complete environment law. No, by no requirement. You are not supposed to be a machine. You are supposed to be a human being only. And believe me, please remain a human being only. Do not try to become a researcher or a machine. No. So coming back to the law of crimes, IPC. Besides IPC, it includes Prevention of Corruption Act. It includes Protection of Civil Rights Act, and it includes plea bargaining. These are the few topics which are included in law of crimes. It is not only about IPC, but believe me, 95% is IPC. 95% is only IPC and rest it is 5%. For IPC, I don't know which book you have referred, but whatever book you have referred in the past, that is more than sufficient. No need of focusing upon any new book. If you have gone through S.N. Mishra, if you have gone through K.D. Gord, if you have gone through, the T. Bhattacharya, or any other book, or Ratanlal Dheerajlal, it doesn't matter. No matter. The only thing which matters is how thoroughly or how properly you have gone through that particular subject. If you know the fundamentals of IPC properly, if you remember how the IPC operates, if you remember how does IPC actually operates in a commission of a crime, it is more than sufficient. No necessity of referring anything unnecessarily. So if you have gone through like Pillai as well, so my only suggestion is that main book of yours will serve the purpose. That will guide you. Even in the lectures, when we just discuss with you about the basics of a particular topic, so those topics will also give you the idea how you should prepare for any subject. So coming with this law of crimes, first of all, it discusses about the general principles of criminal liability like mens rea, actus reas, and mens rea in the statutory offences. So the question is, we have to discuss about few fundamental principles of the criminal liability. It is necessary for all of you to get an understanding how the legal provisions are actually applied. Okay, so the mens rea and actus reas, every time in the previous year question papers, you can see one question from the general principles of criminal liability. And similarly, the kind of punishments and the emerging trends of the abolition of capital punishment, even the emerging trends of the pardoning power, or the probation of offenders act. So these are the few things which everyone should be very well aware of. Okay, then comes the preparation of the criminal attempt, preparation and criminal attempt. Generally, the preparation is not the criteria of the punishment, but the attempt is. So the various stages of crime, and then ultimately, at what level of that stage the person will be held guilty. Similarly, the journal exceptions. In IPC, every year, you see the questions from journal exceptions. Section 76 till section 106. Just cover it thoroughly here. You are going to secure the marks. Think smartly. No need of doing the hard work, believe me. Once you start reading the things by looking at the pattern, and then you prepare yourself, brace yourself, you achieve the target. Do not go with the haphazard pattern of learning, haphazard pattern of reading. No. Think smartly. That is the work of the teachers over here, whereby we tell you what topic, which topics the students should refer to, and what should be the depth of focusing upon that particular topic. After that, we have abetment, joint and constructive liability, criminal conspiracy. After section 107 till section 120B, we have these sections with us. and section 34, section 149. So these are the one of the easiest topic in this IPC. And generally you see one question from these three topics. Out of these three topics, one question generally. And why I'm telling you all these things with so much confidence? Because I am thinking from the perspective of a paper setter. If I would have been the paper setter in UPSC and after going through the syllabus, if I would have been given the questions for the paper, I would give the topics, the questions only from these topics. Because I am a teacher since last 20 years and my mentality is clearly from the paper setter perspective. Last year, I specifically advised, and even this year as well, I have advised my students about few questions. And believe me, last year, 90% of the paper of law optional was only from those guess, the guess questions. The questions which I have guessed last year, 90% of the paper was only from that particular questions only. So by this way, you prepare yourself. So think from the perspective of the paper setter. You will get the questions first and then start writing the answers. Then we have offenses against state, against public tranquility, against human body, against property, against women. Out of these 5 topics, as of now, the focus of the government is upon human body, property, and women mainly. Offenses against women. Like for example, nowadays, there is a new word that is digital rape. Yesterday, there was one incidence of digital rape in Noida. So generally people get confused. What is this digital rape? How it happens? What are the provisions of this digital rape in IPC? This word is nowhere mentioned. Actually, this is the nomenclature which is not correct actually. It should be digit rape. But they have given this name digital rape. So digit rape actually. Digit means the thumb or the fingers. So if any person is doing any such activity by using his fingers or thumb of hand or of legs in the private part of any women, so that comes under this ambit of digital rape. So this term has got attention recently. If you have observed the pattern in the newspapers, you can find the word many a times. So this question might be the question in this year in mains examination. Digital rape. UPSC might ask what are the various provisions of digital rape in IPC. So there are no specific provision as such, but the provisions are specifically, if you have gone through section 375 definition, the amended definition, the latest definition of section 375, you could easily write down about this digital rape. Because the definition clearly provides about the completely or in detail about the rape, the definition, how the inserting or the insertion basically comes under the ambit of rape. So start thinking about all these things. You are not supposed to go through the machine learning. You are a human being. Paper setter is a human being. So remain as a human being and think about the question pattern. You will get all your answers. Then comes defamation. Generally, UPSC asks one question from defamation on alternative basis so that you can prepare. Then Prevention of Corruption Act. This has become one of the most important topic recently. This has become one of the most important topic because of the recent amendments in this act, as well as the discussion about corruption in our country. So this topic is, you can say, having a lot of importance for you. Then we have Protection of Civil Rights Act, which was basically about the prevention, or you can say specifically Article 17, abolition of untouchability. So what was the reason behind this particular act? Why this act is still necessary? So these kind of questions you can, figure out the answers and write down by simply referring the current affairs. Then plea bargaining, it is a thing of CRPC, whereby the accused, they bargain for the, the punishment. So plea bargaining. So if you go by this discussion, you can figure out you are not supposed to go through the entire IPC Bail Act. No need of reading this entire IPC Bail Act. No. Do not read IPC from the judicial perspective. No. You have to read IPC only from the IAS perspective. So the approach of preparing IPC in judiciary examination and in IAS examination is altogether different. It is not same. Okay. Then comes law of torts. If there is, a topic which is very simple, number one, which can be understood by any person of any age, is law of torts. So law of torts is a subject whereby you can write down the answers even if you do not remember or do not, if you have not gone through the subject. This is just a kind of question paper, a subject. So law of torts covers various perspectives like law of strict liability, absolute liability, vicarious liability. Every time you see questions from these three principles. Every time. Then general defenses. One question is fixed from general defenses. Then joint tort features, remedies, negligence. Negligence, from negligence, it is one of the important topic. Negligence. People, UPSC generally ask this question every time. Defamation. So defamation in IPC, the criminal offense, and defamation over here, the civil suit. So we will read defamation from both perspectives. Then nuisance, conspiracy, false imprisonment, malicious prosecution. These are very small topics, and UPSC sometimes they ask the questions from these topics. Sometimes. Now the focus of UPSC about law of torts is very less. Main focus is upon IPC. And in law of torts, another, the subject which they have added, Consumer Protection Act. And this is also very relevant for all of you because CPA is now fully new amended act actually, 2019. And recently government has also issued various guidelines as well under the new law about the improvement in this consumer protection law. So in CPA, just try to figure out, like recently the government has issued one guideline that the restaurant cannot charge 10% service charge. So the service charge cannot be levied by the restaurants now. But this matter has gone before the court and now the matter is pending, sub judice right now. So keep a watch on this kind of news, and once news is finally out, start writing the answer without thinking any if and but. Okay. Now coming to the law of contracts and mercantile law. Actually it covers first of all law of contract, that is Indian Contract Act. It covers law of indemnity, guarantee, insurance, contract of agency, sales of goods act, partnership act, negotiable instruments act, and arbitration and conciliation act. And a small topic, that is standard form contracts. So these are the few topics which are there. First of all, Indian Contract Act. After the law of contracts, the law of torts, if there is a subject which is most easy, which is really very easy, that is law of contract. Every law student, they start their, the study from the law of torts and law of contracts. So if you are very well aware about the basics of law of contract, then you do not find any difficulty in appearing for this examination. It is very easy, very, very, very easy. Simply refer any of the standard book like Bangia or Avtar Singh or N.D. Kapoor or any other book of your respective state authors. No need of focusing upon any separate book or any study material. No requirement at all. No, nothing. Okay. Then there are small topics of the Contract Act, the small parts, basically the indemnity, guarantee, agency. These are the very small topics which we will cover in our discussion in the classroom program, and as well as the concept clarity, the concept classes. The main focus of yours should be upon Arbitration and Conciliation Act. Your main focus should be upon this act, arbitration. Because recently, government is mainly concerned with this arbitration law. Arbitration law. Even government is emphasizing or focusing upon this subject, this area of arbitration. It is nothing, it is just the modified or the advanced version of Panchayat system. I will discuss with you in the class, the concept classes, about this arbitration. Then standard form contracts, it is a very small topic, nothing else. I will give you the notes of this as well. And then Negotiable Instruments Act. In Negotiable Instrument Act, the biggest mistake the students commit, they start reading this entire act from the very beginning. No need of reading these things now. Just focus upon Chapter 17 of the Negotiable Instruments Act, which is mainly concerned with the check bounce matters. Or in the initial sections, just cover only few topics like holder and the holder in due course, or the presumptions. Simple, nothing else. No need of reading anything else in the chapter 1 till chapter 16 of Negotiable Instruments Act. Just focus upon a simple question, whether the chapter 17, which is about the criminalization of the check bounce matters, is appropriate or not. Simple. And about CLD, as I have mentioned you, that in CLD, no requirement of referring each and every topic individually. Do not go with this entire subject of IPR or IT law or competition law or ADR or environment law or RTI. No requirement of going through the entry cases or the, the issues or the everything or from the very beginning, scratch reading. No. Just, try to get or just have the watch on the newspapers whenever you see any latest update or any latest news on these topics of CLD, please note it down. Like for example, in 2021, Government of India issued these intermediary guidelines. Okay. So this question was in the question paper about these intermediary guidelines. So just go through these latest advancements only. In environmental law, the main emphasis of UPSC is not about any law, but about NGT, National Green Tribunal. So whether the National Green Tribunal is effectively working or not, or what are the issues it is facing, what is the deficiencies in the system. These are the few topics of the discussion which you come across in your life. So my main advice to all of you of the previous lecture, that was about paper 1 or whether it is about paper 2. I have to only presume that you have already covered this entire syllabus. Now you need only the revision or only the brushing up the concepts, the final, you can say, clarity about the concepts. And mainly the focus should be upon how to write down the answers. That should be the agenda of yours. If I presume that you are already aware about this entire everything. So if you are very well aware about each and every subject already, please start writing answers by keeping in mind that all of your answers should relate except this mercantile law or like IPC as well, except this mainly in paper 1 and in CLD mainly. Your answer should be related with the current affairs. You should relate your answers with the current affairs. Please consider this advice of mine very seriously. Because you should have actual clarity about the current events which are happening around this world, and then try to link those topics, current affairs, in your answers. This creates a positive impression in the minds of the paper checker, and you get reward in terms of the marks. In the first lecture, I gave you an example of the answer sheet of already UPSC, as the past candidate. His answer sheet was so basic, so simple, no case law, no section, hardly any case law was mentioned by that person, hardly any section was mentioned. But that person was an IPS officer already. So it doesn't matter. But the main point was his answers were very, you can say, like they were not very lengthy. That person has tried to explain the concept in a very simplest language, in a very simple manner. That was the only thing which was given in that answer sheet. So please be, please avoid unnecessary discussion or unnecessary overthinking about the, utopian answer. No answer can be perfect. No perfect answers can be given by anyone, even not any teacher can write down a concrete or a completely perfect answer. No, not possible. Humanly not possible. Even I will be lacking, or the most famous teachers might be lacking at some point of time. So avoid overthinking this unnecessary kind of information. No, not at all. So I will just finish my class over here right now, because the approach is only about these points. Rest I will discuss with you about the first topic of constitution, that is constitutionalism, in the next lecture. Thank you all of you. Thank you very much.